This picture on the screen is taken from Bay Street in Toronto, which is the economic and financial capital of Canada, and it's the city in which a lot of corporate transactions take place. But we are here in Vancouver at the UBC School of Law, and I am here to talk to you tonight. My name is Camden Hutchison. I am a professor here at the law faculty. I'm also the director of the Center for Business Law here at the law school. The Center for Business Law is an academic center that is engaged in a lot of academic and professional activities related to business law. The courses that I'm teaching this year are business organizations, corporate transactions, and economic analysis of law. And my research involves both corporate and constitutional law, and I'll talk a little bit more about that at the end of this presentation. But I'm going to start off by talking about myself, and I feel a bit self-conscious doing that. I don't necessarily love talking about myself, but I think that I'm, given that I'm speaking to undergraduate students, I think it is relevant to talk a little bit about my backstory and how I became a corporate lawyer and then a corporate law professor. So I am originally from the United States. I grew up in upstate New York, and I went to university at the University of Rochester in Rochester, New York, where I studied history. So, I was an undergraduate about, 20 years ago. I was in your guys' shoes, and I was trying to figure out what to do with my life. And when I was an undergraduate student, I was a history major, as I said, and I was a very strong student. I got really good grades in my history courses, and I was thinking that I would pursue a PhD in history. Right? I was a nerd. I was really loved my classes. I loved studying history, so I thought I would pursue a PhD in history. That was kind of my first choice, I suppose. But when I did research into the practical realities of the job market, I learned, somewhat to my dismay, that the academic job market for PhDs in history was pretty poor, and there was a pretty significant risk that if you got a PhD, even from a good history department, you could end up not finding an academic position, and you would have to do something else. And this was this was 20 years ago. It's way worse now. But even back then, I was like, job prospects don't seem great. I then did research on going to law school, and it was like, well, if I get a PhD in history, I might be unemployed. But if I get a good grade on my LSAT and I get into a good law school, I'm pretty much guaranteed a high-paying job. And so I signed up for the LSAT at literally the last possible minute, my senior year of university. And I did well on the LSAT, and I ended up going to Columbia Law School straight out of undergrad. So I showed up to law school, right? Some of you, I'm assuming all of you are at least interested in law school. Some of you might end up going to law school. I showed up to law school as a 1L, totally naive, didn't know anything about the law, didn't know any lawyers, no lawyers in my family. I knew nothing, just complete babe in the woods. And I was like, all right, here I am. I'm going to go to classes. And it was sort of a mixed experience in my first year. I did well. I got good grades. But I didn't really enjoy my classes that much. The first year curriculum in law school is kind of like the sort of like classic subjects of torts, contracts, criminal law, constitutional law. I hated criminal law, didn't like torts that much, didn't like contracts that much. Constitutional law was okay, but it wasn't really something that was driving my passion. And so after the first year, I was a bit worried. I was like, oh man, I kind of went to law school by default, and maybe it wasn't the best choice. And then in my second and third year, I pursued business law courses, just to try that out. And I really enjoyed my business law courses, right? Like as soon as I started taking business law courses in my second year, so taking corporations, securities, corporate finance, courses like that, I just found those courses a lot more interesting, a lot more stimulating. I really enjoyed them. Again, I didn't have a business background, right? I was for latecomers, there's space up front. But I just really took off in those courses, and I kind of focused on that when I was in law school. And I was pretty sure that I wanted to do something in the corporate law arena when I became a lawyer. I ended up getting a job with a law firm called Kirkland & Ellis, which is a large US-based law firm that is actually based in Chicago. So I got my job and I summered in their New York office, and then I decided to go to the Chicago office after I graduated. So literally the day after I graduated from law school, I moved to Chicago, Illinois, and I worked as a corporate lawyer for Kirkland & Ellis for about 5 years. And I was an M&A lawyer, so I worked in an area of law called mergers and acquisitions. Did that for, 5 years, felt like 15. It was a extremely demanding lifestyle, very, very intense work environment, really long hours, really high amounts of stress. And that's not to say that I didn't like it. I did enjoy it. I found it very intellectually stimulating. I found the actual, work that I was doing for clients, very stimulating, really rewarding in a lot of ways. But it was a lot. It was really too much, in terms of lifestyle, in terms of stress, especially. It was quite brutal. So I realized, I'd say after about 3 years, it was not something I wanted to spend the rest of my life doing. And so I did what a lot of people do who work at big law firms, is after 3 or 4 years, you figure out something else to do. And so in my case, I was trying to figure that out. I wasn't quite sure what to do. The obvious options are go, work in-house, or maybe work for a smaller law firm, something like that. Neither of those options seemed particularly interesting to me. And so, I was sort of, I guess I was sort of privileged, you might say, in that I didn't have a family to support. I was single at that time. And I was financially independent. For reasons I won't necessarily go into, I made a lot of money in the stock market. That's kind of a whole other story. But I was sort of like, kind of in the situation where I had plenty of money, and I didn't necessarily have to be a corporate lawyer anymore. And so what I decided to do is I was like, you know what, I'm going to go and I'm going to get a PhD in history. And that's what I did. So I quit my job in my law firm, and I was like, I'm going to get a PhD in history. And everyone I knew told me I was insane. No one encouraged me except for my parents. But I was like, I want to get a PhD in history, and my goal was not to become a history professor at this time, but I wanted to become a law professor. So I was like, my plan is I'm going to use my PhD in history as sort of an inroad to the legal academic market and get a job as a law professor. And that is exactly what I did. So it took me 6 years to get my PhD, and I went on the job market in 2017, and I was primarily focused on the US market. For the obvious reason is that I'm from the US and I was living in the US at that time. But I did apply to a couple of the big universities in Canada just because I was worried that I might not get an academic job. Right? So in 2017, the legal academic job market was not that strong. And so I was like, oh my God, I'm going to strike out. I'm not going to get a job. I was like, well, I guess Canada could be like my backup plan. So I went to a couple of big universities in Canada. I actually did very well in the job market. So I got a number of job offers in the United States, which is great. But I happened to get a job offer at UBC because I applied here. And, they flew me out for my interview. My job interview for UBC was the first time I'd ever been in Vancouver in my life. And I was really blown away by the city of Vancouver, by the University of British Columbia, just the research resources available to professors here, the quality of the students in terms of admission metrics, the salary was very good. So I actually ended up taking a job in Canada at UBC, which was, not my plan, but that was just kind of the best option I had. And it was a really good option, and I've been here for 8 years, and I love being a law professor, and I really like UBC. So that's kind of my backstory, and I'm happy to, answer more questions about how I, decided to become a corporate law professor, and, how I felt about working as a corporate lawyer when we get to the end of the session. But some of those questions might be preempted by the substantive content of what I'm going to discuss for the next 45 minutes or so. Okay, so let's talk about law school. I am a law school professor. Again, I'm assuming most of you are interested in potentially going to law school. So one of the first things that you should know about law school is that for reasons of culture and tradition, law school in North America focuses overwhelmingly on litigation. So all first-year courses and many upper-year courses center on the adjudication of various types of legal disputes. That is the pedagogic focus in your first year, and then for much of your upper years is litigation, the resolution of legal disputes. So there's lots of different types of legal disputes, right? Criminal law disputes, people being accused of crime, they're on trial, contract disputes, tort matters, constitutional litigation, environmental litigation, right? Just think about kind of lawyers, arguing with each other in courtrooms, trying to resolve disputes. That is really what law school focuses on. That was my experience as a student, and that is my observation as a professor, is that law school focuses overwhelmingly in, maybe not so much in content, but certainly an emphasis on litigation. Now, despite this focus, more than half of all law students in Canada become transactional lawyers, right? They are not litigators, they're transactional lawyers, and I'll explain the difference between the two in a second. But I just want to highlight this discrepancy. There is a substantive focus on litigation and on the role of litigators in law school, but it's actually not what most lawyers do. Most lawyers are transactional lawyers. So what do I mean by a transactional lawyer or a corporate lawyer? I'm going to be using the terms corporate lawyer and transactional lawyer interchangeably. They are not exactly the same. I guess in theory, a corporate lawyer is any kind of lawyer who works with corporations. So because a lot of corporations are involved in litigation, I guess you could say that some litigators are corporate lawyers. However, when most people in the legal profession, including myself, say corporate lawyer, what they mean is transactional lawyer. So you hear the term corporate lawyer a lot. That's the term that's most often used. I think it's a little bit more precise to say transactional lawyer, so I'll try to use that language, but the two terms are essentially interchangeable. So in the legal world, there are essentially two types of lawyers in private non-governmental practice. So there's basically two different types of private practice lawyers. There are litigators on the one hand, and there are transactional attorneys on the other. Those are the two main types of lawyers, litigators and transactional lawyers. In Canada, litigators and transactional lawyers are sometimes referred to as barristers and solicitors, following English terminology. So in English terminology, there is a formal distinction between what are known as barristers, who are lawyers who are licensed to appear before courts, and solicitors, who are lawyers who are not licensed to appear before courts. So they just do transactional stuff. In Canada, you do not have that formal distinction. All lawyers have the same right to go to court. However, sometimes Canadian lawyers will still, right, following, Canada's a former English colony, so kind of following that tradition. Sometimes people will use the term barrister and solicitor. Barrister less often, but solicitor you hear quite a lot. People describe themselves as solicitors, but this basically just means litigator and transactional lawyer. So what do litigators do? I think most people in this room probably have some idea as to what litigators do. Litigators represent clients in legal disputes, right? So they represent clients who are involved in legal disputes, and they often do that by making arguments in courts or other adjudicative bodies, right? So your kind of stereotypical image of a lawyer is a litigator, someone who goes to court and they argue on behalf of their client who is involved in some kind of dispute. Corporate lawyers or transactional lawyers do not do that. Corporate transactional lawyers represent their clients in economic transactions, which are not disputes, right? So they help their clients do business deals, essentially. Now, I want to emphasize that the popular understanding of the legal profession is based overwhelmingly on litigation. Now, I don't, people in this classroom, you might have more sophisticated knowledge about what lawyers do, but the average layperson, if you ask them, what does a lawyer do? They're going to think of a litigator litigating in court, right? And I think pretty much every single movie and TV show that you have ever seen about lawyers is really about litigators. It's about litigators in court, right? So just think of like any kind of popular media about lawyers, right? So like Law and Order, they're criminal litigators. Suits, I'm not really sure what they're doing, but they're litigators, right? Better Call Saul, right? That's a great show. I mean, he was in court, right? I mean, you've seen Better Call Saul. What's a name? Here's a challenge. Just like name any TV show or movie about lawyers. And I'm going to guarantee it's about litigators. Yeah. She's in law school technically, but haven't seen Legally Blonde in a while. But yeah, that's kind of pre-lawyer. But any movies or shows that are about lawyers. Yeah. What's that? Anybody.
A Few Good Men.
Yeah, right. A Few Good Men. They're JAG lawyers, right? So they're in military court, but they're litigators, right? They're litigators. Yeah.
To Kill a Mockingbird.
Yeah, he's in court, right? Inside of a courtroom, right? There's lots of lots of media about lawyers, and they're all litigators. Ace Attorney, Phoenix Wright, Ace Attorney. Anyone familiar with that? Anyone know about? Okay, one guy, he knows what's up. We're gonna return to Ace Attorney at the end. But that's another popular cultural product that involves lawyers, and it focuses on litigators. So the point I'm making here is that like almost everything you've ever seen in popular media about lawyers focuses on litigation, and that's not even what most lawyers do, and it's certainly not what I did when I was a lawyer. So I was a transactional lawyer, which meant I worked in the world of business law. And that is what my courses here at the law school attempt to teach. So my courses, I try to bridge the gap between the traditional law school curriculum, which does focus on law after all, and corporate legal practice. I teach two main courses every year, business organizations and corporate transactions. I'll talk about both of those. Business organizations, which is called corporations at many schools. So when I went to law school, it was called corporations. Here it's called business organizations, but it's the same course. That focuses on the law of business organizations. So it focuses on the substantive law of business organizations. Corporate transactions, which is the other course I teach, is a more specialized course that focuses on corporate transactional practice. So that focuses more on the practice of being a transactional lawyer. So I'm going to start off with business organizations, and then I'll talk a little bit about corporate transactions. So business organizations is one course I teach, kind of my bread and butter course. This focuses on the law and governance of business organizations. Business organizations are legal entities that are formed for the purpose of doing business. The corporation is the most prominent form of business organization. It is not the only form of business organization, however. In Canada, there's a number of different types of business organizations. The most significant are the sole proprietorship form, partnerships, and corporations. So those are kind of the three most important forms of business organizations, although there are others. And of those three, I would say that corporations is probably the single most important. So the bulk of my business organizations course focuses on corporations. In my business organizations course, I focus on Canadian law, so I teach both federal and British Columbia law, but I also teach some Delaware law. And the reason that I teach these different areas of law is one of the first things that you learn when you take business organizations is that corporations are organized under the law of specific jurisdictions, right? So corporations are not like these kind of abstract concepts that are just sort of floating in the ether. They have to be organized under the specific law of a specific jurisdiction. And corporations can and often do business in jurisdictions other than the jurisdiction in which they are organized. And there does not necessarily have to be any connection at all between the jurisdiction of a corporation's organization and the jurisdiction in which it does business or in which it's headquartered or which it has assets, right? So corporations are formed under the law of a given jurisdiction, but they can often do business in totally different places. So in my course, I focus on federal and BC law. You can form corporations under federal law. There's a federal Canada Business Corporations Act statute that allows you to form corporations at the federal level. You can also form them under BC law. So there is a British Columbia Business Corporations Act. And here in British Columbia, you can choose either. You can also choose the law of the provinces if you want. But you have a lot of flexibility and optionality as a business person in terms of choosing your jurisdiction or incorporation. And then finally, I focus a fair amount on Delaware law. So Delaware is a state in the United States. And for historical reasons that are certainly interesting, but I'm not going to get into them for purposes of today's or this evening's lecture. Delaware has become the dominant incorporation jurisdiction in the United States. So almost all publicly traded corporations in the US, like large corporations, so like almost any corporation you would have heard of in the US, so like Microsoft, Amazon, Apple, you name it. They're based all over the country, right? They're based in California, Washington, New York, but they're all organized under Delaware law. They're all Delaware corporations, right? So this is just kind of an oddity of the U.S. corporate law system. But given that I practice in the United States and that Delaware law is very important in United States practice, I teach a fair amount of Delaware law. And it's not only because I'm from the US, it's also because if you're a corporate lawyer in Canada who is working on transactions involving large Canadian companies, you are almost inevitably going to be involved in US-Canada cross-border deals, right? So you're going to be working with US entities, you're going to be working with US counterparties, and you're going to be a better practitioner if you understand at least some US law. Okay, so what is a corporation, right? I keep using the word corporation. I'm guessing that most people sitting here in this class, you've probably heard of a corporation, but my guess is probably very few people in the class know exactly what a corporation is. Like a corporation is a very, very specific type of legal entity. Corporation is not a generic term for like big business. Like people throw the word corporation around like, oh, that's really corporate, or this corporation. Like they just use this kind of like synonymous in the business world. That is not precise. A corporation is a very, very precise form of legal entity that is formed pursuant to statutory law. So here in BC, the relevant statute is the BC Business Corporations Act. Corporations are entities that have their own legal personality separate from their members, i.e. their shareholders. So probably the defining quality of a corporation is that it has a legal existence that is separate from its shareholders, right? So the corporation is separate from its shareholders, and the shareholders are separate from the corporation. They are legally distinct. This concept is often referred to as legal personality or legal personhood, right? So in other words, corporations are legal persons. Now that doesn't mean that they're like literally persons, they're not literally human beings, but they are recognized as having their own agency under law, which means that corporations, even though they're non-human abstractions, they can sue and be sued in their own name. They can enter into contracts in their own name. They can hold property in their own name. They can do a lot of things that real life human beings can do, but they do them in their own name. They do them, they don't need to rely on human beings to act on their behalf. They can in fact act on behalf of human beings, right? So they are recognized by law as entities that have legal powers and rights. That's kind of the defining feature of a corporation. Another feature of a corporation, which is probably maybe not the defining feature of a corporation, but the most important feature of a corporation for business purposes, is that shareholders in a corporation have what is known as limited liability, right? So shareholders, they own shares in the corporation, they're the owners of the corporation. Shareholders of a corporation have limited liability. This is the most important business feature of a corporation. What that means is that shareholders are not responsible for the debts and obligations of the corporation that they own, and the corporation is not responsible for the debts and obligations of its shareholders. So the debts of the corporation are separate from the debts of the shareholders, and the debts of the shareholders are separate from the debts of the corporation. This is really important because it means that if the corporation becomes insolvent and creditors are collecting against the corporation's assets, they are not able to access the assets of the shareholders, right? So if you own shares in a corporation and that corporation goes broke and it goes bankrupt, the creditors can only recover against the assets of the corporation. They cannot go against you personally. So if you're a shareholder in a corporation and then your corporation goes belly up and the corporation doesn't have any money, the creditors have no recourse. They can't come seize your house, right? They can't come seize your car because your debts are separate from the corporation. Conversely, if you're a shareholder in a corporation and you go bankrupt personally, your creditors cannot access the assets of the corporation because the corporation's debts and obligations are separate from your own. This is limited liability. It's a very important protection for entrepreneurs who invest in businesses. If you invest in a business, you want to make sure that if that business fails, the creditors of the business cannot come after your personal property, right? So limited liability is extremely important in the business world. Given that corporations have separate legal personality, they're also taxed separately and in addition to their shareholders. This is not necessarily a good thing, but it's just sort of the legal reality. Corporations have to pay corporate income tax on any profits that they earn, unsurprisingly. However, if a corporation earns profits and pays corporate taxes on those profits and then distributes the money that it's earned to its shareholders in the form of either dividends or capital gains, those shareholders are potentially taxed a second time on the same profits because the tax existence of the corporation is separate from the tax existence of its shareholders. Now, fortunately, under Canadian tax law, we have an integrated tax system here in Canada. And so this double taxation problem can be avoided in most circumstances, but it's something to be aware of, that the separate corporate personhood of the corporation, even though it's beneficial in many circumstances, it can also be a negative aspect in other circumstances. Okay, so just really kind of quick on how to form a corporation. So in Canada, corporations can be formed on either federal or provincial law. So if you're starting a business in BC, you can form it under federal law, you can form it under BC law, you can form it under Alberta law, Ontario law, whatever you want. You choose what law you want to use to form your corporation. The federal law in Canada is called the Canada Business Corporations Act, and the law in BC is called the Business Corporations Act, right? And those are kind of like, if you're in BC, those are sort of your two main choices. I would generally recommend that people use the BC Act. It's the most, kind of straightforward for BC companies, and it has certain advantages to it. Delaware corporations are governed by a Delaware statute, which is called the General Corporation Law. So my point here is that every jurisdiction that provides for incorporation has a statute that sets out the process for forming a corporation. That process is usually pretty straightforward. So if you want to form a corporation, incorporation generally involves filing certain administrative paperwork, which is not particularly burdensome. It's pretty easy to file, and then paying a moderate fee. So the fee under BC law is $350, right? So you fill out the forms, you pay $350, you get a corporation. This incorporation, I really want to emphasize this, in British Columbia and in almost all modern jurisdictions, we have what is known as a general incorporation system. And what that means is that anyone who fills out the required administrative paperwork and pays the fee, they are entitled to incorporation. It's a general incorporation system. It means all you have to do is fill out the paperwork and pay the fee, and the grant of incorporation status is non-discretionary. The government must grant you incorporation, right? They don't review your business plan. They don't do a credit check on you. They don't do a background check. Right? Anybody who fills out the forms correctly and pays the fee, they get a corporation, right? It's kind of a democratic process, right? It's like anybody can have a corporation, right? So like anyone sitting in this room, if you're willing to pay $350, by next week you could have a corporation, right? You could have a corporation in your name that you own and that you can do business with, right? The government cannot deny you corporate status. Corporations can be either public or private, this is an important distinction that I'll mention briefly. Private corporations, when we talk about private corporations, we simply mean corporations that are not registered on public securities exchanges. That's all we mean. And when we say public corporations or public companies, we mean companies that are registered on public securities exchanges. So are registered on like the TSX or the TSXV or the New York Stock Exchange in the United States. That's the distinction between a private and a public corporation. Public corporations, because they're publicly traded, their securities are publicly traded, they are subject to an elaborate disclosure and regulatory regime that is referred to as securities law. So basically, if you publicly register on a securities exchange and you are selling your shares to the public, you have to provide a tremendous amount of disclosure to the public markets. That is sort of the burden that you have to bear to be a public company. And a legal regime that governs this disclosure and kind of all the rules about the trading and the sale of securities, first is securities law, and it's not something that I teach by and large in my business organizations course, because at UBC and most other law schools, there is a separate securities law course. So you take an entire course on public companies that is called securities law. So what do I teach in BizOrgs? BizOrgs, it's sort of a black letter law course. It's a large lecture course, and I really focus on the substance of corporate law. So specific topics include jurisdictional and organizational choice. How do you form a corporation? I talk about the sale of investment securities and corporate finance. So like, how do corporations raise money? I talk a lot about directors' duties and corporate governance. So corporations are governed by what is called a board of directors, right? And those directors have fiduciary duties to the corporation. So I talk a lot about the nature of those duties and how those duties are performed and enforced. I talk about control transactions. What I mean by control transactions is buying and selling companies, basically. So M&A. That's what I mean by control transactions. And then I talk about shareholder rights and remedies. So what are shareholders' rights and how do they vindicate those rights? That's BizOrgs. So now I'm going to talk about my corporate transactions course. My corporate transactions course is kind of like the way I do it is BizOrgs is actually a prereq for my corporate transactions course. So corporate transactions is kind of like advanced business organizations. And it builds on the legal content of my BizOrgs course, but it focuses much more on practice, right? So the course is really intended to prepare students for corporate transactions. It's really tough for students to know what it's like to be a corporate lawyer or what it's like to be a transactional lawyer. I didn't really know, right? When I was in law school, I was taking corporations, I was taking securities, I was taking tax, I was taking all these kind of business related classes, but I had really no idea what it was like to actually be a corporate lawyer. And I didn't really learn until I got a job and I started practicing. Law school, by and large, does a very poor job of providing students with information about what it is like to work as a corporate lawyer. So in my corporate transaction class, I try to rectify that a bit by sort of showing, we go through deals, we go through deal documents, kind of describe what the tasks of a corporate lawyer are. And I try to prepare students for, what the kind of like day-to-day life is as a corporate lawyer. So what do corporate lawyers do? This is the $1 million question, right? I don't think very few people who are not literally corporate lawyers know what corporate lawyers do, right? It's not something that gets a lot of attention in popular culture. It's not something that gets a lot of attention in media, despite the fact that it's 50% or not more of all lawyers. So what do corporate lawyers do? I'm going to try to explain. It's actually very difficult to explain, so I'm probably not going to give you a great idea as to what corporate lawyers do. But I'll do my best in the limited time available to me. Corporate lawyers represent businesses with respect to deals, right? So if you're a corporate lawyer, you do deals. You help your clients do deals. You are a deal lawyer, right? So corporate lawyers, you ask them, what did you do at work today? they're going to tell you about deals. They're like, I was working on this deal. I was working on that deal. This deal just started. That deal just died. We closed this deal. Deals, right? They do deals. That's what corporate lawyers do. They help their clients close deals. What do I mean by a deal? It's not that complicated. A deal is simply a business transaction. So corporate lawyers represent their clients in business transactions. There are many different types of corporate deals. I just have some on the screen. Mergers and acquisitions is a major area of corporate deals. Mergers and acquisitions means corporations buying and selling each other. That's what mergers and acquisitions means. That's what I did. I was a mergers and acquisitions lawyer. 90% of the legal work I did was mergers and acquisitions. Most of my clients were private equity firms, and I worked primarily in private equity mergers and acquisitions. Another type of corporate transaction is securities offerings. These are sales of equity or debt securities. So IPOs, secondary offerings, these are when public companies raise money by selling securities to the public. That is a different type of deal. Secured lending. This is when corporations borrow money from banks, right? So a big corporation might need like a giant loan from a bank. They might need $1 billion loan from JP Morgan or something like that, right? That $1 billion loan is going to be, documented by hundreds and hundreds of pages of legal documentation, right? The lawyers are going to negotiate and draft all of that documentation, right? By documenting the transaction, you're helping your client land that deal. Real estate transactions, right? Real estate could be personal retail real estate. In this context, I'm thinking more of like corporate real estate, right? But think of like, Vancouver is a city with high real estate values and therefore a lot of real estate development. A lot of these, these big real estate developers, I mean, they're structured as corporations. They have all sorts of corporate entities, right? They're doing multi-million-dollar real estate transactions. Being a real estate lawyer is another type of deal lawyer. And then finally, just sort of general commercial transactions. So this might be, big supply agreements, big customer agreements, joint ventures, partnerships, that kind of thing. But these are all different forms of business deals. So working as a transactional lawyer means working as both a legal and a business advisor. You are advising your client as to the legal issues they may face in a particular business transaction, but you're often also giving them more general business advice, right? If you're a deal lawyer, you're somebody who works on a lot of deals, right? Every day in and day out, you're helping clients with deals. So you have a lot of experience that can benefit your clients. You're often providing your client with both business advice and legal advice. Now, the sort of institutional dynamic that most differentiates deal practice from litigation is that when you're working on a deal, you're representing your client who is trying to close a deal with a counterparty who is represented by their own counsel, right? So you're representing your client's trying to do a deal with another business, and that other business has its own lawyers. So you are working across the table from the lawyers of the counterparty, right? And you're trying to maximize your client's interest. They're trying to maximize their client's interest. But unlike litigation, which is a zero-sum game in which there is a winner and a loser, a business transaction is a positive-sum game. A business transaction is a win-win. Both your client and the counterparty, they want the same result. They want to close the deal. Now, obviously, you're going to negotiate to try to, make sure that your client has more of an advantage than the other party. The other party's counsel is going to try to negotiate so that they have more of an advantage than your client. But at the end of the day, it's a win-win. Like both parties want the deal to close, right? And so working with opposing counsel on a business deal is often a collaborative exercise, right? You're negotiating, right? You're trying to maximize your client's interest. But at the end of the day, you know that your client and their client want the same thing. And ideally, both sides are trying to help their clients reach the finish line. Now, that's not to say that negotiating deals is never adversarial, because sometimes it is. And in my experience, I worked at a very large law firm in the United States. And one of the things that I've learned since becoming a law professor in Canada is that negotiating deals is often much more adversarial in the United States than it is in Canada. So my experience as a deal lawyer, it was, at the end of the day, you would close the deal and everyone would, congratulate each other and be happy. But like on the route to getting there, it was a very adversarial process, right? You'd be in extremely, heated negotiations, often very confrontational negotiations, a lot of conflict, people yelling on conference calls, people losing their temper, a lot of F-bombs thrown around. It was a very adversarial, that's part of the reason why it was very stressful. It was a very adversarial process. In Canada, I've learned that is not the case. So in Canada, business culture is different, legal culture is different. People are a lot more polite. I know it's a stereotype, but it actually is the reality that in Canadian legal practice, it's less intensely adversarial, for better or for worse. But even in the United States, right, the idea is that you're trying to get to the same result. This is totally different from litigation. Litigation, there is a winner and a loser, and you are a pit bull on the attack, right? You are trying to ensure that your client wins and their client loses, right? And it is a negative sum game. It's a negative sum game if you include transaction costs, right? Only one person is going to win, one person is going to lose, and both sides are going to pay a lot of money to lawyers, right? As you can probably tell, I have a sort of a negative conception of litigation. But the key point here is that transaction lawyers hate litigation, right? And I'm a consummate transactional lawyer in that sense. Is that transactional lawyers, their number one goal whenever they're negotiating a contract is they want to make sure that their client does not end up in litigation, right? Litigation, from the perspective of a corporate lawyer, is the absolute worst case scenario that you want to avoid at all costs. You never want your client to end up in litigation. The very thought of litigation horrifies you. You don't ever want to see the inside of a courtroom ever in your life. I'm going to share an anecdote that I related to my corporate transaction class the other day because I think it's applicable. I also think it's funny. So I'm a corporate lawyer, right? I'm a lawyer, supposedly. And I have been inside of a courtroom literally once in my entire life, right? There's probably people in this class who've been in courtrooms more often than I have. I've been in a courtroom exactly once ever. I was a lawyer for 5 years. I've been a law professor for 8 years. I literally teach people law. I've been in court once ever, and it was to defend myself against a speeding ticket. I went to traffic court to defend myself against a speeding ticket. Crushed it, got out scot-free, walked out of the courtroom, Teflon Don style. And that was my only experience as a litigation. I was a pro se litigant for myself, defending myself against a speeding ticket. And it was I don't know if I should be proud or ashamed of this experience, but I went to traffic court, and the way, I don't know if it's different, I don't know how it is in Canada, but in the US, the way that traffic court works is like in a lot of jurisdictions is you like get a speeding ticket, and then it's like your choice is like you can either pay the speeding ticket or you can go to court. But if you go to court, you almost always get the ticket dismissed. It's just kind of like, are you willing to bear the inconvenience of going to court? But it's like, unless you have like a really bad argument, although I in fact had a bad argument, you're generally going to get off. I got off. I won my case. I am batting 1,000, 1 for 1 in my litigation career. Very impressive. But my experience is I went to traffic court, right? So I went to traffic court, and there's like a line of people who are like all trying to get their like parking tickets dismissed or whatever. And it's before this judge who he's been assigned traffic court for the day, so like he doesn't want to be there, and he has to like deal with all these people. And I went to court, and I was like, oh, I'm going to wear my suit and tie. I'm going to look like a real lawyer, which I did. And I'm in line with all these people who are wearing like hoodies and like look like bums. And so I was like, I got this. And then I got it for the judge, and I was like, Your Honor. And the situation was I got pulled over going I got pulled over going 41 in a 25. That's miles per hour. So 25 miles per hour, that's like 40 kilometers an hour. So I got pulled over going 41 in a 25. And the judge was like, what do you have to say for yourself? And I was like, Your Honor, I was like, the speed limit was 25. Really? That's really slow. And the judge, he like literally rolled his eyes. He's like, all right, dismissed, next. And because he just had like a whole line of people. So my argument was that the law was dumb. That was my argument, which is like, probably would not work in other contexts, but it worked for me. So the point I'm making here is that court sucks and you don't want to be there. And so being a corporate lawyer is better than being a litigator. I'm struggling a bit here. It actually is quite difficult to explain what exactly corporate lawyers do. And trust me, they work very, very hard. It's a very, very challenging, very, very demanding practice that requires a tremendous amount of work ethic, a high degree of intelligence, and a great degree of conscientiousness. So it's not a trivial profession by any means, but it's weirdly difficult to explain. So transactional practice is very complex. And in the interest of time, I'm going to try to distill it into what I would describe as 3 core universal functions. And when I say universal, what I mean by that is that all deals share these 3 functions. So I don't care if you're doing M&A, I don't care if you're doing real estate, I don't care if you're negotiating a supply contract. You're always going to be engaged in these 3 core tasks. And I've identified them as negotiation, drafting, and execution. So negotiation is negotiating the terms of the deal with the counterparty and their counsel, right? So you're negotiating the terms of the deal. You're doing a negotiation, right? Like, Donald Trump style. You're negotiating the deal. Drafting is drafting the legal documents that evidence the deal, right? So any complex corporate transaction is going to involve a purchase agreement, and then it's also going to involve a constellation of ancillary agreements that are supportive of the purchase agreement. So what I mean by that is basically every corporate deal is going to involve hundreds and hundreds of pages of paper that document the deal and provide the legal evidence of what's happening. And it is the job of the lawyers to draft all of that paper, to produce all of that paper. Right? So once you negotiate the deal, you then have to reflect the terms of what has been negotiated in written form, right? In the form of agreements. And then the third task is execution. And what I mean by that is closing the deal, right? So once you've negotiated the deal and once you've drafted the relevant documents, you have to get everything together and close the deal. Now, each of these functions requires different skills. I would say that negotiation requires social intelligence and the ability to communicate effectively. I think that those are very important skills in negotiation. I think drafting is the most intellectual task that corporate lawyers are involved in. It requires cognitive skills. It requires abstract thinking. It requires the ability to translate complex abstract ideas into written language. And then execution requires process skills. The closing of any deal is an extremely messy and stressful situation, right? So any deal, when you're trying to close it, you have to have basically all of these boxes ticked, all of these documents signed, all of these consents confirmed, all of these permissions granted, and you have to get it all done by a certain time and a certain day. And every single deal, there's a million things that goes wrong, right? So you're dealing with all of these last minute disasters. You're herding cats. All of these problems come up. Everybody's stressed out. It's high stakes. And, especially as a junior associate, you're the person who has to deal with that. You're the person who has to you have to put out all those fires, make sure all those problems get solved. And that requires a steady hand, right? It requires ability to work under pressure, and it requires an ability to get things done, right? So I think that being a corporate lawyer requires strong social skills. I think it requires strong cognitive skills. And I think it requires strong process skills. Now, what is the value of transactional counsel? Ideally, corporate lawyers help their clients solve business and legal problems. And I say ideally because not all corporate lawyers actually do that. I worked at a law firm where I was trained that the role of a corporate lawyer is to be a problem solver, right? Your client is trying to do a deal, and they're going to face a number of legal and business challenges. They're going to face a number of legal and business problems. Your job as their lawyer is to solve those problems, right? Your job is to lubricate the process, come up with creative solutions, give your clients advice that will help them achieve their goals, right? You are a problem solver. Unfortunately, not all corporate lawyers see themselves that way. And some corporate lawyers are actually problem creators. So some corporate lawyers, their client's like, I want to do this deal. And then the lawyer's like, well, actually, the law says that, and like, that's the kind of lawyer that clients hate, right? Because if you just tell your client that they can't do things, right, you're just frustrating the process and they're not gonna like you. What you need to tell your clients is like, look, the law says this is an issue, here's a solution. Right? We can do it this different way. We can use this alternative structure. We can ask the counterparty for this concession, right? This is how we're going to navigate this issue. But if you just tell your client, you can't do that, you can't do that, you can't do that, right? Your client's going to hate you and they're not going to hire you for the next deal, right? Now, unfortunately, a lot of lawyers, that's all they know how to do. All they know how to do is spot issues and say, that's a problem, that's a problem, that's a problem. That doesn't add any value, right? You add value by helping your clients solve problems and navigate those issues. So corporate lawyers should do more than simply help their clients navigate the legal system. They should add value by helping their clients resolve both economic and legal issues. And the best corporate lawyers, and I worked at a law firm, which I do think that we were excellent corporate counsel. And the best corporate lawyers, they become trusted business advisors. So their clients turn to them not only for legal advice, but for business advice as well, right? And they turn to them for their experience and expertise based on all of the deals that they've worked on and all of the issues that they've experienced. Okay, so that's kind of it in terms of my spiel about being a corporate lawyer. I'm going to talk very quickly about some of my academic research, which is maybe a little bit less interesting for the current audience, so I'll be quick. My research, my academic research, I've written a number of articles. If you Google Camden Hutchison SSRN, you'll go to my SSRN page, and that has all my articles. But a lot of the research I've done has actually involved exactly what I'm talking about right now. So kind of the practice of being a corporate lawyer. I've also written quite a bit on fiduciary duties in Canada. And so tonight's lecture is not about fiduciary duties, so I'm not going to go into too much detail. But corporate directors who manage corporations, they owe fiduciary duties to the company. So they have a duty of loyalty to act in the company's behalf and to avoid any conflicts of interest, right? So this is a really important duty that corporate directors have. And sort of the nature and the meaning of that duty in Canada is somewhat is a bit ambiguous, to be honest, and is a bit contested. So that's a fruitful ground for research. And then my current research I've been working on lately actually has nothing to do with corporate law. So recently I've been researching more on constitutional law. I wrote an article on freedom of expression under the Charter. I recently wrote another paper on freedom of peaceful assembly under the Charter. So I've been writing about some charter issues. That's kind of a unexpected development in my academic career, I suppose, but I do enjoy learning about and writing about constitutional law, so that's hopefully something that I'll continue. But I don't want to talk too much about my research, so I will just kind of conclude by saying that corporate law can be a rewarding field for lawyers that are interested in business. However, I will warn you that it can also be tedious and unsatisfying for lawyers who are not interested in business. So if you have no interest in business, and if you take business law classes and you're like, man, this is boring, I really don't like this, you should not become a corporate lawyer because then you're not going to like your job. I think a lot of people go into corporate law for the money. They're like, well, you can make a lot of money as a corporate lawyer, so I'm going to be a corporate lawyer even though I don't find it inherently interesting. I think that's a really bad idea. I think you are much less likely to thrive in your career if you are doing something that you are not interested in or that you have no passion for. So I would advise against that. And my advice to you guys as undergraduate students is try to develop as much information as you can about going to law school, about different areas of law that you can practice, before making any long-term career decision, right? So do your due diligence, try to learn about what lawyers actually do before making a decision to go to law school, because it's a big commitment. And if you do go to law school, try to learn about different practice areas before you commit to any one of them, because that could also be potentially a big commitment. So I'm just going to kind of end the one guy who knew the Ace Attorney reference. He just walked out of the classroom, which is unfortunate. So I'm going to explain what Ace Attorney is. So this is the kind of the Q&A part, and also so that the joke here is you can ask me a question, you can also object. He's saying objection, so you can object to anything I said if you want. Ace Attorney, he's back. I'm explaining Phoenix Wright Ace Attorney. Phoenix Wright Ace Attorney is a series of video games, originally for the Game Boy Advance and then the Nintendo 3DS. The Japanese video games start where you play the role of a lawyer arguing in court. So it's like a video game based on litigation. And one of the mechanics is it's like kind of story driven, but if like certain things happen, you can like literally do an objection. It's like a special move. So you like press a button, he's like, objection, and then you like get points. So it's pretty cool. Anyways, that's my presentation. So I would be happy to answer any questions that anyone has. And Nancy, do you want to pass around the mic or?
Yeah.
So we've got a microphone, assuming people have questions, I can use them.
Yeah, it's helpful. I don't know if there's any vegetarian left though, but yeah.
Anyone have any questions?
There might not be questions.
Oh, all right, but
Do I have to use a microphone?
Yeah, because we're just recording.
Okay.
Is this on?
Sorry, you just turn it on.
Hi. So, on average, how many deals do you have to do at the same time? Like,
That's a good question. It depends on how busy your practice is. So when I was in practice, I would say usually working on, I would say on average 3 deals at once. So I'd be working on 3 deals simultaneously. I had a very busy practice. So if you're in a practice that's less busy, you might just be doing 1 deal at a time.
that's for like big law, right?
Yeah. So I worked in like a big law office. Yeah.
Just out of curiosity, what was it about in-house work that wasn't interesting for you?
I mean, working on deals, working in a big law firm on deals is really exciting. It's really exciting. I mean, it's too exciting sometimes, but I liked the excitement of it. And it was also like, this is going to sound a little bit weird, but it was like very extreme. Like it was like a really extreme lifestyle. Like it was just sort of like, you were like pulling all-nighters and like you're on conference calls with like people screaming at each other and you're working on these like multi-billion-dollar transactions and it's just like crazy. So it's like a really crazy lifestyle. And I feel like when you're in-house, it's much more of like a 9-to-5 job. And you're just providing kind of a legal counsel function for some company. And I don't know, just not for me. Like, it's just like, I'm not like, even my job now as an academic, it's not extreme in that way, but it's sort of like, it's a job where it's like I'm actually quite passionate about the stuff that I research and I'm quite passionate about teaching and I make my own schedule. Like, it's kind of a weird job. And like, I'm kind of a weird person. So like, I feel like I just sort of thrive in work environments that are more just different or, and I feel like the 9-to-5, working at some company, it just wasn't appealing to me. I don't know. But obviously my answer indicates it's totally personal to the individual.
Okay, so hypothetically, what about like an in-house and like a private equity firm? Would that be any different?
Yeah, I think that would be cooler. Like I would be more attracted to that. I remember I actually interviewed for and almost got a job working for a hedge fund not in a legal role, in a deal role, like, and that would have been super cool. I think I didn't get the job, unfortunately. If I had, I'd be like super rich now, richer. Yeah, I think working as in-house for like a private equity firm, I think could be cool, with the caveat that very few private equity firms have in-house counsel. Private equity firms are very small, lean organizations, and my experience is that they rely on their outside counsel for the kind of stuff that if you're working as in-house counsel, you're working for like a big company, right? Small organizations don't have in-house counsel. So I think working in-house for a private equity firm would be cool, because the private equity industry is really interesting. And I think private equity professionals are like really interesting people to work with. I just don't think, maybe like the biggest private equity firms in New York might have in-house counsel, but I doubt any in Canada do.
Awesome, thank you.
Thank you.
I was wondering if is bankruptcy another transactional law topic, or is that just
Yeah, so good question. Bankruptcy is a weird one, because, and I've never worked in bankruptcy, but what everyone says, everyone in like the big law world, including bankruptcy lawyers, what they say is that bankruptcy is sort of a unique area of law, and that bankruptcy is a hybrid between transactional law and litigation. So if you're a bankruptcy lawyer, you go to court, right? You argue over court orders. So you're like doing deal stuff 50% of the time, and then you're like going to court and doing litigation stuff. I was kind of bad mouthing litigation, but I think bankruptcy practice actually sounds like it would be really interesting. So it's sort of it's kind of an interesting combination between, because like any bankruptcy process is sort of a combination of a deal and then also a court process.
Thank you. And then my last question was, when you were explaining how, as an investor, if you invest in a corporation, they can't take any of your assets. During bankruptcy, how does that affect like the people who are higher up, like CEOs? Do they lose assets in their bankruptcy, or?
No, the debtor is the corporation, and the corporation, given that it's a distinct legal person, it's separate from all of its shareholders, it's separate from all of its employees, it's separate from all of its managers and directors. So like, if you're the CEO of a corporation that goes bankrupt, you might lose your job, but nobody's going to be able to come after your personal assets.
Okay, thank you.
Hi, so you've spoken a little bit about your dissatisfaction with your big law experience in the United States, and how it's different from in Canada. I was wondering, had you practiced in like big law, large corporation, large firms in Canada? Do you think that would have been more sustainable for you? I'm personally interested in this because I'm a dual citizen, Canadian American. Hi. I'm fellow American, not a great time for us right now, but I just like to get a comparison. I don't know how much you worked in that capacity here.
I mean, yeah, it's kind of hard to respond to a counterfactual, but I would say probably, yeah. I mean, like, I liked being a corporate lawyer. Like, I don't want to say I was dissatisfied. I liked it. I liked the law firm I worked for. I liked the people that I worked with, even though some of them were terrifying. So I liked the experience, and it's a time, I have no regrets. I mean, I look back at the time of my life with fondness, but I think it would have been more sustainable if it was more sustainable, I guess. So like if the hours were less, if it was less stressful, I probably, there's a world in which I, would be like a partner at a law firm or something, like maybe if I worked in Canada. And my observation is, I have not worked in Canada, but my observation is that in Vancouver, the work-life balance is much more favorable. And I think it's a pretty good balance. So the trade-off is like, if you're working as a corporate lawyer in Vancouver, you're making a lot less money than big law lawyers do in the US, because like big law salaries are like they've really gotten up there. Like they're like pretty obscene. And I do have students from UBC. I've had a few students who've gone and worked in New York. It's a trade-off, right? So it's a trade-off between, money and lifestyle, I suppose. And I feel like in Vancouver, it's like a good mix. Like you work hard, but not too hard. You don't get paid as much as the US, but you still make a good living. And if you stick for the long term, if you become a partner at a firm, I mean, you can make a very handsome living. The work is high level, it's interesting. So, I mean, my philosophy is that everything in life is a trade-off, right? You're always making trade-offs in your life. You just have to figure out what works for you. That said, I do think that the Vancouver market is an attractive balance. That's sort of my outside observation.
Thank you.
Hey, I had a really quick question about, so when you came out of Columbia Law and then you said you worked at a firm in Chicago, how did you pick that firm? Like, was it something specific? Did you have other firms kind of offer you?
You know what? I don't even really remember. So at Columbia, you go through a structured recruit process, similar to the process that they have here at UBC. And so you interview with like a whole bunch of law firms, and then you get a whole bunch of offers, and then you choose one. And I chose the law firm that I worked at. And to be honest with you, like I think I said this at the beginning of the talk, like I was pretty clueless when I was a law student. So I just, I was like, whatever, like I was like 23 years old. I was just like, I don't even know. Like all these firms seem great. And I chose the firm I chose. I think maybe I just liked the people that I interviewed with. I don't think it was a very informed decision. I think it was it was a good choice. I would say that the firm I worked at, just to say a little bit about my practice experience. So I think the United States has a reputation for like the practice in the United States. It's really demanding and in the corporate area, like I said before, like it's a lot more adversarial, it's a lot more high conflict than in Canada. And I think that that's kind of the stereotype of the United States. So like the firm that I worked at is notorious, even in the US, for being like the worst firm. Like in terms of like, not like the worst firm, but like the most, just the most brutal environment, right? It's also like, you can look this up, it's the most profitable law firm in the world. So, everything is a trade-off, right?
Cool, thank you.
You say what again?
He did say, well, I don't know.
So just circling back to your days at Columbia, I know you haven't seen the inside of the courtroom all that much, but during your time at Columbia, did you ever engage in, moot court, informal legal debates, something of that sort?
I did not. Nancy, is the moot court here, you have to do a moot court?
Yeah.
So it's a required moot court. So Columbia, it was not required, it was just like strongly encouraged. It wasn't even like strongly encouraged, it was like moot court. So at UBC, apparently, Nancy, my assistant, is a current law student. At UBC, it's required. When I was at Columbia, it was like everyone did it, but it was not required. So it was like everyone did it because like law students, like, I don't know why, but like law students tend to all do the same thing. It's like this like real sort of like herd mentality where it's like everyone's like, oh my God, you have to do this. And then people like get really anxious. They're like, I better do what everyone else is doing. But like moot court, I was like, it's not required and it's a lot of work. So why would I do it? And so I didn't do it.
Thank you.
Maybe I would have become a litigator, who knows?
I have a question concerning, for example, for an M&A lawyer, right? How much of it is this paperwork versus how much of it is actually like talking to people, whether it's on the phone, whether it's in person?
Yeah, that's a good question. I think, and that kind of speaks to like the day-to-day lifestyle. I would say, yeah. So like versus like writing versus talking, maybe like 50-50. Honestly, and then I mean, there's probably other stuff I'm forgetting, but that's kind of like the two main things are like being on conference calls or like drafting documents. That's kind of like the main things that you do. And yeah, like 50-50. Yeah.
Yeah. And is M&A's like is there like another form of corporate law which has more talking, less paperwork? Is that something? I want to avoid paperwork, so.
The paperwork is it's not paper. So just to like the paperwork is the fun part. So the paperwork is it's not mindless paperwork. It's not like, oh, you have to like go to the DMV and like fill out forms. It's not mindless paperwork. It's like really, really intensely intellectually challenging drafting, right? So it's like you basically have these like very, very complex abstract concepts that you need to translate into the form of a written contract using very precise language. And it's really where you exercise your cognitive skills the most. Like that was the part I loved. I actually loved, like, I'm like, don't call me, don't email me. I just want to like sit down and like, I want some me time to like figure out this document, right? Because it's like putting together a puzzle, right? It's like really, so for me, I didn't like the phone calls. Like I didn't like the meetings. I didn't like the intense conversations with people. Like I was like, no, I just want to like shut the door to my office and like work on this document. Like that's the part that I liked. But in terms of like, where do you do more? I would say there's probably other areas. I mean, I wouldn't know because I was only an M&A lawyer. But there's probably other areas of law where you do more negotiation. Like honestly, like if you're like a divorce lawyer, I think you do a lot more negotiation. That's not really a deal lawyer though. Yeah, you got me stumped. I think if you're I want to say, I wouldn't know for sure, but I think it's probably the same in different areas of transactional practice. So if you really want to like talk to people, I was being facetious, but like honestly, like being a divorce lawyer or being the kind of lawyer who's like engaged in these kind of more social negotiations. So like somebody who's like, I guess that becomes litigation adjacent though. So if you're like somebody who's involved in like mediation processes or something like that.
Yeah, what about real estate law? Would that be something?
I think real estate law, I mean, I was not a real estate lawyer, but my impression is that real estate law is actually pretty similar to M&A, but more boring. That's kind of that's my general impression, yeah. Because real estate is real estate, right? Real estate, you're buying and selling real estate. Like, real estate doesn't have a lot of surprises to it. When you're buying and selling companies, there's a million surprises. There's a million things that go wrong. There's a company is like a very, very complex organization with lots of people, and there's lots of crazy things that can happen. A parcel of real estate is a parcel of real estate. So I just feel like you have to deal with way more issues in M&A. I didn't say this in the talk, but like, I do think that M&A is the most interesting area of corporate law, personally. I did try so I didn't only do M&A. I tried other things when I was a junior associate. I tried securities work. Venture capital work is actually very cool. Venture capital work is very interesting. I didn't have the opportunity to do a lot of it. But M&A is like way more interesting than securities. And that's actually relevant because if you're going to be a corporate lawyer in Vancouver, there's a lot of securities work in Vancouver, and I do not recommend it. I think the securities work is really boring. I strongly recommend M&A over securities work. The securities work, there's a lot of securities lawyers out there. So
I'm just interested in, so you said that in your undergrad, you did history and then you went straight into law school. And then you very quickly found, business law and corporate law. And that as a corporate law, you need to know a lot about business. How did you kind of bridge that perhaps knowledge gap from, I think a lot of people here are actually from Sauder. I'm an English major. Mm-hmm. So how did you get to there?
Yeah, so I was a history major. I didn't have any formal background in business, and I didn't have any particular knowledge of business, and I had no work experience. So I went to law school straight out of undergrad. So I guess I would say a couple of things. I really took to business law. So when I was in law school, I took my business law courses really seriously. I learned a lot about business. When I was a law student, I took a corporate finance class through the Columbia Business School. I took an accounting class through the Columbia Business School. So I kind of went out of my way to learn as much business as possible, which I think was helpful to being a business lawyer, but not necessary. There are lots, let me put it this way. On the one hand, I think the more business stuff you know, the better, if you want to be a corporate lawyer. But on the other hand, there's lots of excellent corporate partners in big law firms who were English majors, and they learned everything about business on the job. So I think the more business you learn, the better, but I wouldn't say it's necessary.
Hi, sorry. One more question on note. When you were in big law, what would you do for fun or just to distract yourself?
Nothing. I had no life. Literally nothing. I had no life. I had no hobbies. I had no recreational activities. I rarely went out. one of the reasons that I went to grad school, one of the reasons I quit my job, and I'm not making this up, one of the reasons I quit my job and went to grad school is I was like literally in my mind, I was like, you know what? I need more time to play video games. I don't have enough time to play video games. And so that was one of the reasons I went to grad school. Man, it was bad. Like, it was like, 80-hour weeks, working all weekend. There's nothing outside of my job. Like, maybe every other weekend I would like go out to the bars. That was like my only release. Like, there's just like nothing else. It was really all consuming. And, that's, like, it was kind of unsustainable. Yeah, it's funny because like when I went to grad school, I was like friends with this guy in grad school, and like everyone I went to grad school with, they were like all, they were all like Marxists. I think so. They were all like like I was a PhD student who was like used to be a corporate lawyer, so they were all like fascinated by the fact that I was a corporate lawyer. And like this good friend of mine, like I love the guy, he's like a good friend of mine still. But I remember one time he asked me, he's like, "Oh man, you were a corporate lawyer." He's like, "That must have been like the lifestyle." He's like, "Must have been really like work hard, play hard." I was like, "Nope." It was like work hard and then work hard more. Like there was no play hard part to it.
Thank you.